original creditor being Capital One. After a period of non-payment on the account, it was subsequently charged off and assigned to Portfolio Recovery Associates LLC. In today's case, you should have in front of you account-level documentation to that effect, including a sworn statement and affidavit from the Portfolio Recovery Associates, as well as assignment documents showing that the transfer of the account from Capital One to Portfolio was proper. And finally, you should have relevant account statements in the file, as well as a charge-off statement to the amount that's requested in the amount of $4,687.42.
Okay. So you're asking the court to award $4,682.45?
$4,687.42 plus cost of court. The plaintiff is not requesting post-judgment interest or use fees.
Okay. Okay, is that it?
And yes, that's our opening statement, Judge.
Okay. So we're doing opening statement. Okay. Mr. Simmons, do you want to do an opening statement before we get to the evidence?
Yes, yes, I do. My opening statement is, first of all, this is a Portfolio Recovery versus Theodore Simmons case, JX 200082H. Today, this case is about alleged portfolio recovery, purchasing an alleged debt by me, Mr. Simmons, from Capital One Bank. The problem with the plaintiff case is there is no plaintiff today. A lawyer can appear. He can make arguments, but a lawyer cannot prosecute and testify in a case that is well known in Trenches versus Pigalario. Now, in order for there to be a controversy, there must be a plaintiff before the court. An attorney can appear, but he cannot both testify, bring in documents. I haven't been served on any affidavits, no documentation on me. What were to be used today with due process. Today, this case is about documentation that cannot be authenticated. No one here to testify. I cannot cross-examine anyone concerning the documentation.
Okay. Thank you, Mr. Simmons. Mr. Kettler, why don't we go ahead and move to the evidentiary phase? Sir?
Sure, Judge. And if I understand correctly, and Mr. Simmons, please correct me if I'm wrong here. Your argument seems to be just two parts here. One, you're claiming that there is no plaintiff, and two, that the evidence isn't properly authenticated. Is that correct? Am I understanding your argument correctly?
That is absolutely correct.
Okay. And Judge, that's ultimately just a determination on your end if Portfolio Recovery Associates is a proper plaintiff based off of that in front of you. And as far as authentication of documents is concerned, I think it's relevant to point out Texas Rules of Evidence 101 at exception for Justice Court's case, clearly showing that there is no specific requirement for authentication. These rules do not apply to Justice Court cases except as authorized by Texas Rules of Civil Procedure 500.
I'm going to have to object to that. He's basically stating the rules, Your Honor.
Okay. Thank you for the objection overruled. Mr. Kettler?
It's really down to if the evidence in front of you is sufficient to show our account stated theory that there.
I'm going to have to object, Your Honor. I don't see.
Mr. Simmons, your objection.
But there's no plaintiff here, Your Honor.
Objection.
So this whole process is unfair.
Okay.
You trying to.
Mr.
Okay,
Simmons,
but you letting a lawyer.
I'm
you
going to
letting
let him finish,
Okay.
and then I'm going to hear from you, as I always have,
Okay.
Mr. Simmons.
I apologize.
I would appreciate you
I apologize.
allowing for him to finish. It's just, I know you're upset because you're here, but the process works, sir. Let's let it work, okay? Mr. Kettler, anything else, sir?
Other than just what we have in front of you today, Judge, it should clearly show beyond the preponderance of an evidence that there was an agreement, there was an understanding that there was activity on the account, as the statement should show, and that there was a failure to make payments in accordance with that agreement. Based off of that, we respectfully request judgment in favor of plaintiff. And I have nothing further pending rebuttal.
Sure. Quick question for you, sir. Are you asserting that you have filed an affidavit in this case? A business record? A business records affidavit?
Judge, there should be an affidavit of the account.
Okay. If I were to tell you it was not in there, would you understand why I am going to rule against you today?
Judge, I respectfully dismiss this case.
No.
No, you done
No, we're
started.
at trial now. We're gonna render a judgment in favor of somebody today. I'm telling you, there's not an affidavit in your jacket today. You have 2 assignments, and you have it looks like a bill statement, but there is no affidavit in this jacket.
Judge, there should be an affidavit from Diana Hayes as part of the documentation.
Okay. All right. Thank you.
Can I question?
This not question. Why don't you just summarize? Because I think it's
Okay.
pretty clear.
Your Honor, I haven't received any affidavit, any documentation from a witness. And part of due process is if they have documentation that they feel like at any time they could have moved for summary judgment with those documents, giving me an opportunity to see them, make an argument. I haven't seen them. Most of the time when a plaintiff feel like they have a case with the documentation, they will move for summary judgment and let the court look at that. But today, the portfolio recovery has not presented sufficient evidence. And I also like to bring to the court's attention that there's a court case in the Fifth District Court of Appeal, Powell versus Vero McDonald. And it says anytime a business record is placed in, the person making the business record must have personal knowledge of how to other the entities when they transfer this alleged account. That's not before the court, and I asked the court to grant judgment against the plaintiff because they haven't carried their burden of proof.
Okay. All right. Mr. Kettler, I'll tell you what I have in the jacket so you are aware. I have a bill of sale from a Jonathan Stalls. I have a bill of sale again from Jonathan Stalls dated January the 28th. I have what looks like some sort of just record run from a computer, and the court has no business records affidavit. You don't have one, do you? Rebecca says she does not have one.
No
Okay.
affidavit.
No affidavit. Okay. So the court is going to grant judgment in favor of Mr. Simmons today. You can file an appeal. You have 21 days. Okay, that's the ruling of the court. Thank you. Have a good day. I'm drawing out this computer. And
What I handed to you is
Oh,
for
we'll
the
know
chief
you.
court.
You
We're
a mail
gonna
it to
have
me?
to mail you.
Okay,
Yeah.
thank you. Y'all have a nice day. Excuse me. Game over. Oh, game over. How y'all doing?
Good.
Victory sweet. Oh yeah, got a victory today. They tried to pull up here. Oh, Judge kept the cup in there. Kept the cup in there. It's all right. Oh, my mother. This should be good. Leaving the courthouse, got a victory.